Good afternoon, everyone, and welcome to Simple Steps to Estate Planning. I'm Virginia Hazlip, and I'm a partner at McCandlish Lillard. I'm here with my law partners, Belinda Merck and Elizabeth Gray. We run the Trust and Estates and Elder Law Department at McCandlish Lillard. We're going to spend about an hour this afternoon talking about why people don't do estate planning, what estate planning is, the goals of estate planning, what happens if you don't have an estate plan, what assets go through probate, what assets do not, the core estate planning documents, how to choose a fiduciary, and then revocable trusts and their advantages. Afterwards, we'll be happy to answer any questions. You should see a button at the bottom of your screen for Q&A. Please submit your questions there, and we will come to them at the end of our presentation. So we also have slides as part of this webinar. If you'd like to receive a copy of the slide, or if you have any questions that you don't want to submit generally, please feel free to contact us at trustestate@mccandlaw.com via email. We will be happy to send you a copy of the slides, answer questions, or schedule a time to meet with us one-on-one. Before we get started, we have a polling question for you to complete. We were curious as to how many people here attending this webinar have wills. It should pop up on your screen, and if you would please answer, we'll all see the compilation of the results.
Do you remember what it was last time?
While we're waiting for the polling results, I will just kick off and just talk about some general statistics. And it's from caring.com. They do an annual survey. And as of the end of last year, they surveyed over 2,400 Americans. And overall, only 1/3 of the folks surveyed said they had one or more estate planning documents in place. So we'll see how that compares to our poll results, if you're able to pull those up, Liz. And as the slide shows, if you break it down further by age group, you can see that the folks who are 55 and plus, at least the numbers are a little better, but they have still declined since the polling numbers from the prior year. So our results. So our audience, as we would have expected, has exceeded the average in that it says 63% of you do have a will, and 38% of you don't. So another question I think we would want to ask is for those of you who do have wills or other estate planning documents in place, when was the last time you updated them? And so we're gonna talk about that as well as to when you do have current documents, when you might want to think about updating those. Just a couple other notes about the survey. Despite the poor numbers of those who actually have estate planning documents in place, the respondents also stated that over 60% of them feel that estate planning is important. So there is a disconnect there, between who actually has estate planning in place versus those who don't. And there's various barriers that the survey also reflected. Of course, one of the most common barriers, people are too busy. The cost can also sometimes be a barrier, but one of the increasing things that the survey has been showing is a lot of people just don't know how to get started. And so that's one of the goals of our seminar this afternoon. Is we hope we can give you a little more basic information to help you actually start the process. I'm going to turn over to Virginia to talk more about exactly what is estate planning and what are we trying to accomplish.
Thanks, Melinda. So when people hear the term estate planning, I think the first thing that comes to mind is what happens when someone passes away. But estate planning is not just about what happens when you're dead. An estate plan is also about controlling what happens when you're alive but incapacitated. With the recent coronavirus pandemic, many people have wondered what would happen if they were hospitalized, if they couldn't take care of themselves, and if there's anything that they could do to be better prepared. And estate planning is not just something that wealthy people need to do. Frequently we hear, well, I don't have enough money to need to do an estate plan. That's just for rich people. But almost everyone needs some basic estate planning documents. Most people want to be able to control the things that happen to them during their lifetimes and at death. It's about planning for someone else to make decisions for you if you are incapacitated. It's about protecting your assets from your creditors, your children's spouses, and long-term care costs. It's also about income tax planning, legacy planning, and doing what you can to preserve family harmony. So what we have here are some goals of estate planning, and these are things that we talk about with our clients about what their individual goals are. So can you go back one slide, please? Thank you. So we've touched on many of these goals, which of course, protecting assets, leaving a legacy, passing on not only money, but what your values are and what your family's ideals are. And these are things that you can do with the proper documents. Okay. So let's talk about what happens if you don't have an estate plan. If you become incapacitated, the court may appoint a guardian and or conservator to manage your financial affairs and take care of you physically. We're going to talk about guardianship and conservatorship together using the term guardianship. This is a court process. It will require the appointment of a guardian ad litem, who's a third-party attorney, who will do an investigation and prepare a report. Once a guardian and or conservator are appointed, they will have to make reports to the court periodically. You may have to get court approval to make decisions for you, like moving you from one facility to another or taking care of other financial decisions. If you don't have a guardian appointed, the court may also appoint a guardian and conservator for your children if you and the other parent are not available. If you die without a will, the court will supervise the probate process to distribute your assets according to the state law, not according to your wishes. So your beneficiaries may inherit assets that you may not intend for them to inherit. You may have a situation where assets are passed to someone who's not going to take care of them, who's going to spend them outright. Or even more unfortunately, you may have assets passed to a special need beneficiary. That can be very problematic because that can cause that beneficiary to lose eligibility for Social Security, for Medicaid, and other public benefits that they may be entitled to. So doing some basic estate planning can allow you to avoid these outcomes that you would not want to have happen for yourself or for your family. And I will say for myself and my husband personally, the thought of our children being cared for by someone that we didn't want them to be cared for was one of the factors that made us finally take care of our estate planning documents. And that may be true for someone who's listening today. You certainly want to make sure that you select the people who will care for your children if you are unable to do so, or if you die before they reach adulthood. So there are certain assets that don't go through probate. Liz, can you walk us through what those assets are?
Sure, but before I do that, I was going to have Melinda talk about the probate process.
Yes, thank you. I touched on that briefly, but yes, Melinda, can you tell us more about the probate process and what's involved with that?
For anyone who hasn't personally gone through it with a friend or family member, similar to the guardianship process, where if you lose capacity during your lifetime and the court needs to intervene and appoint a guardian, but more commonly it's at your death. Any assets that are titled in your sole name that do not otherwise pass by beneficiary designation, and then the other assets that Liz is going to speak about on this slide, essentially the title to those assets is frozen at death. And so the only way that the bank accounts can be accessed, that the house can be sold, is if either whoever you've appointed as your executor under your will, or if you have no will, one of your heirs needs to petition the court to be appointed either as executor or administrator if there is no will. And this entails that making an appointment with the probate court, which can often take several weeks, especially under our current situation. They've had to make a lot of modifications with all the social distancing and the courts not being fully open. And that person needs to personally appear in the state of Virginia, at least, to qualify, even if they're from out of state. And and then once they are appointed, that then gives them the ability. They get a certificate of qualification that then they can take to the bank. They can give to the title company and be able to access the accounts. But that's just the beginning. Then you have to file an inventory reporting, the date of death value of all the assets in the probate estate. And what is really onerous is you have to file annual accountings, which in the state of Virginia, Commonwealth of Virginia, those accountings must balance to reflecting all additional funds that have come into the trust, and more importantly, all additional funds that have expended for expenses and any sales, and then before you can get the court's approval to make the final distribution. So it's very time-consuming, expensive process, similar to the guardianship process, but it's even more drawn out, and it typically takes a year, on average, or longer. So that's the probate process. And so a lot of people try to, come up with these ways to avoid probate, what we're calling probate workarounds on this slide. So Liz, if you want to run through.
Sure.
This slide.
So the assets that generally don't go through probate would be those assets that are owned jointly with rights of survivorship. So husband and wife own their home joints with survivorship. When the first spouse dies, the second spouse, surviving spouse, gets that asset in its entirety. You can have rights of survivorship with real estate, bank accounts, other types of accounts, and that takes care of the problem for the two people or more with rights of survivorship. The problem always is for married couples that you're planning for what happens at the death of the survivor of the two of them, and not necessarily when the first spouse passes. So I get a lot of people coming in and saying, oh, we own everything jointly, we don't need to do a probate. We don't need to do estate planning, and that's not necessarily true. But it is one of the workarounds that you could do. The other are assets that pass by beneficiary designations. So if you've got a life insurance policy or a retirement account and you name your beneficiary, that will avoid probate and go directly to the designated beneficiary. Generally, automobiles and boats and other types of vehicles can be transferred at DMV. You don't need to do a probate just to transfer a car or a boat. And then something we'll talk about later are assets in a revocable trust.
Liz, the one bullet point I don't want us to miss on this slide is the caution there we've noted about putting children and or other family members as joint owners on your accounts. That is a common probate workaround that we see often, and it's one of our pet peeves. It can result in various adverse and unintended consequences, including, you know, that joint account owner, that child, has the ability to, you know, withdraw all the assets from the account, and you know, you may trust your child, and so that's not a concern. But it also exposes that account to the child's creditors, and so that's not good either. And it can also cause some unequal distributions if you have more than one child, but you're only putting one child's name on all your accounts because maybe they're the child who's local and you want them to be able to access the account to pay bills. But there are better ways to handle that, like using a power of attorney, which we'll talk about here in a minute.
I just want to add that for Medicaid planning purposes, adding a child to your real estate or to a bank account could cause gifting penalties. And if you add your child to your real estate, and then you need your child to consent to selling the real estate. So there are a lot of implications, and that's why we all think of it as a pet peeve. So
right.
Now we're going to talk about the core legal documents that a person needs to have. And I'm going to start today talking about the most important document you need in light of the coronavirus, and that's an advanced medical directive. An advanced directive is generally a term to describe primarily two documents that allow an individual to express what their healthcare wishes might be if they were in circumstances where they could not express those wishes themselves. Typically, they're referred to as the living will and a healthcare proxy, or a durable healthcare power of attorney. In our office, we combine everything and call it an advanced medical directive. The living will is the document that states the patient's preferences for different types of treatment in different circumstances. And in particular, the living will addresses end of life circumstances. So if that person is in a persistent vegetative state, or that person's given a terminal diagnosis with anticipation that he or she may reach a point where he or she can't make their own decisions, the living will express whether or not that person might want life-sustaining treatment, or they would want life-sustaining treatment withdrawn or withheld. The healthcare proxy appoints an agent to make the person's medical decision if that person can't do so on his or her own behalf. I'm really fussy about the type of medical care I would or would not want. And so I'm relieved that I have a document that names someone who understands what my preferences are and is willing and able to advocate on my behalf to make my medical decisions if I'm unable to make them myself. Do either of you have any more thoughts on the advanced medical directive? Okay, I'm going to move on to the durable financial power of attorney. The durable financial or general power of attorney is durable because once you sign it, it survives your incapacity. So even though you become sick later and can't handle your own financial affairs, the people you appoint under this durable general power of attorney will be able to step into your shoes and make those decisions for you. For example, if the stock market goes down further, actually let's start coming back up. Now that's a depressing time. Let's be positive and say if it continues to go back up, then your agent would be able to buy or sell stocks on your behalf. If bills become due and you're incapacitated, whether it's from another pandemic or a personal situation, maybe you had a stroke, the person you appoint as your agent would be able to pay your bills and make sure all your financial affairs continue to be in order so that there is no eviction notice from your landlord or a foreclosure notice from your mortgage company. There's no shutting off of your electric or canceling your iPhone carrier. It's important to do the power of attorney with a competent estate planning professional to make sure that it survives your incapacity, to make sure it's durable. This document is not something that takes effect when you die, like a will does. A will only controls your assets when you die. The power of attorney controls what happens to your affairs while you are still alive, but unable to manage them yourself. The durable power of attorney terminates when you die. So remember the importance of appointing the right person as your agent for while you're alive to take care of your financial affairs. So this person has to be someone that's good with money, someone you trust. We're going to talk about choosing the agent of fiduciary later on, but I want to ask Virginia, since you have minor children, what else you need in your core estate planning documents.
Right. So as I said, one of the most important documents for my husband and myself was standby guardian and also designation of a guardian for our children in our will. These documents appoint someone to care for your child or children if you become incapacitated or upon your death. And that's a very important document for us to have in place so that we know if something happened to us, our children would continue to be cared for by someone we know and trust and not, God forbid, be in the foster care system. So those are very important documents to have. And typically we also include a power of attorney in our standby guardian document so that if someone is caring for your child, they have the authority to take them to the doctor, enroll them in school, do important things like that that will allow your child to continue living as normal a life as possible. So, and that brings us into the will list. Do you want to talk about that?
Yes. So we already pointed out what a probated estate administration is, but I'm just going to point out two things. The will appoints an executor or a personal representative, the same thing, to administer the terms of the will. And as Virginia said, the will appoints a guardian for minor children if that's needed, and it can appoint a trustee for any testamentary trusts. A testamentary trust means that it's a trust that is built into a will. So if it goes through probate, it's going to be monitored by the court system. But you could have a testamentary trust for surviving spouse, for children, or other beneficiaries. But remember that the will only governs the disposition of assets that a person owns in his or her own name. In other words, the assets that are not owned jointly and assets that are governed by a beneficiary designation or other type of contract designation that establishes where those assets would go at death. What are some of the means in which you can avoid probate? Well, one of those is the beneficiary designations that we spoke about earlier, or joint survivorship, but one of the things that we haven't mentioned on this list is a revocable trust. A revocable trust is really just a container for your assets. It appoints a trustee, which is oftentimes the person setting it up, and a successor trustee to ensure the effective management of your assets in the event of your incapacity and at your death. In many instances, it avoids the need for a guardianship and a probate.
Right. So the core estate planning documents that we recommend every person have are an advanced medical directive, living will, durable healthcare power of attorney, which in our firm we combine into an advanced medical directive, a durable general power of attorney, a last will and testament, and if appropriate, a revocable trust and an appoint by of standby guardian. So before we move on to talk more about revocable trusts, we're going to review some of the key estate planning terms that you'll hear us reference throughout this presentation.
Yeah, we get a lot of people that ask us what the difference is between a fiduciary and an agent and what all those terms mean. A fiduciary is an umbrella term describing an individual who is in charge of another individual's stuff or person. It's a position of trust, of loyalty, of avoiding conflicts of interest. and keeping accurate records of what you do with that individual's assets. Each name under the umbrella of fiduciary describes different jobs or essentially a different document. So an agent is appointed under your healthcare advanced medical directive or your financial power of attorney. An executor is the person appointed in your will responsible for administering the decedent's estates. Trust or co-trustee, trustee or co-trustee is the individual or institution appointed in the trust document to administer and manage the trust estate. A term that we probably won't be using that often is a trust protector, which is an individual other than the trustee designated in the trust who may be granted certain special powers over the trust, such as the ability to remove and replace trustees, or change trust situs, or make certain amendments to the trust. Lots of times when we're doing special needs planning, we'll have in a trust protector as a way to add in a family member as part of this trust, but not give them the day-to-day management authority. The grantor or settlor is the individual who is creating or transferring assets into a trust. Some people use the word trustor, all three of them, same thing. Beneficiary is the individual or entity designated in the trust document or in your will who may receive income and or principal distributions from the trust or the assets through the will. The guardian is appointed, and that's the person who has custody of your minor children if both natural parents are not available. And we sometimes use that for adults with disabilities who have a guardianship in the court appointed.
So Liz, you talked a lot about the different terms for fiduciaries, but one of the most difficult decisions is how to choose a fiduciary. So we can talk about the criteria that we recommend that you look at to address who you should choose to be your agent under these various documents.
Thank you. Yes, you absolutely have to pick someone you trust to carry out your wishes and to act solely in your best interest. If that person can't balance their own checkbook, believe me, they will not be able to balance your checkbook. If that person isn't going to be able to say no to the doctor wanting to provide some treatment at the end of your life, they're not the appropriate person to appoint. Somebody who is organized and pays attention to details and record keeping. With your healthcare decisions, again, someone who is going to respect what your wishes are and advocate for you. Generally, we prefer that families don't name children or other family members as co-fiduciaries. And that's because what if they don't agree? If they don't get along? You want one chief. That's sort of my philosophy. And then a backup fiduciary. Oftentimes with the financial piece, it's just because it's so difficult. I like people to consider banks or trust companies or a professional fiduciary as the backup or co-fiduciary with a family member. And this is especially true in second marriage circumstances where you've got children from different sides of the family, and it could just be a terrible position to put somebody into. Your designated fiduciary will generally need to hire professional advisors with regard to legal advice, tax preparation, and investment management. Do you guys have any more rules of thumb that you sort of stick to in hiring somebody to be your co-fiduciary or your successor fiduciary?
One question we get often is, does it matter if the person is local? All my children live out of state, and for the most part, especially these days where everything is done electronically, it doesn't really have much of an effect. In Virginia, it can have an effect with regard to who you appoint as executor under your will, because there's additional surety and bonding requirements that have to be met if your executor does not reside in the state of Virginia. And so that's probably the biggest disadvantage.
Right, and I think Liz, you touched on, it should be someone who knows you well and knows what your wishes are. And once you've chosen that person, come back to this in a little while, but it's important to let them know that you've chosen them, of course, and make sure you have ongoing conversations with them about what your wishes are. So I think we can go back one, I think, and Melinda will talk a little about revocable trusts.
Yeah, so we've touched on revocable trusts just to provide a little more detail, and it is an additional step and does involve a bit more work on the front end as you get in place as part of your estate planning, because of your part of the process is you actually execute the revocable trust document. I'll talk more about how that document is designed and how it works. But then the second really equally important part of it is doing the funding of the trust. And I know we have some financial advisors on the webinar this afternoon, and they're very familiar with the process of that retitling of assets that would be in your individual name that otherwise have to go through probate, that would be frozen at your death. Retitling, which oftentimes involves opening a new account, but not always. Retitling those assets from your individual name to your name as trustee of your revocable trust. And because once you've completed and you've properly funded your revocable trust, the trust then actually owns legal title to the property. And so during your lifetime, typically you're serving as your own trustee. As long as you have capacity, you might want to name a adult child or other trusted friend or advisor as a co-trustee who could be able to immediately step in and take over if needed. But because we're actually going that extra step and we're retitling the property from your individual name into your name as trustee of your trust, you avoid the whole probate process at death that I described. And then also, when you're still alive, if you do lose the capacity to handle your own financial matters, whoever you've named as your successor trustee or co-trustee can step in, as I said, and just take over managing things. So it's a much more robust tool, planning tool, and for those reasons, much more acceptable and accepted by financial institutions and real estate title companies versus just dealing with an agent under a financial power of attorney, which is also a very important document. But again, it's because it's just not going that extra step of actually having the trust own title to the property. You can also provide more specific guidance in your revocable trust as to, if you're no longer able to act as your own trustee, how you want to be taken care of first and foremost, whether you want all steps possible to be taken so that you can stay and remain and be cared for at home, and how you want the trust assets to be managed. You can provide a lot more detail and direction in the trust document than you can in a financial power attorney, where you're just really giving the agent the authority to act on your behalf. Because the revocable trust document avoids probate and guardianship, it ensures that your assets are not made public record, and or that no, not part of any court proceeding, which is public record. It avoids the ongoing court accountings that I talked about because you're avoiding probate. It really does replace your wills. So all the dispositive provisions for who you want to get your assets at your death are, instead of being in your will, are in your revocable trust document. And during your lifetime, as long as you have capacity, the revocable trust does remain completely revocable and amendable. It's 100% includable in your estate, so there's really no tax advantages. That's not one of the reasons for having a revocable trust, although you can include certainly tax planning as part of the trust provisions. Also, because it's completely revocable and amendable, and the grantor is usually the sole trustee and beneficiary during their lifetime or along with their spouse, you're not gaining any asset protection. And so the assets in the revocable trust compared to an irrevocable trust, which I'll talk about later, remain completely accessible by your creditors. And in terms of there's no additional tax return typically that's required to be filed. The revocable trust is disregarded as a separate taxable entity, and so any sort of income or deductions that would be allocable to the trust assets just go on the grantor's personal income tax return.
So one of the questions that we get is, when should you consider doing a will versus going to the extra step of having a revocable trust? So there are certainly certain circumstances where it may make sense to have a will-based estate plan rather than a trust-based estate plan. So if the couple or individual has limited assets and or assets that would not otherwise require probate at death, such as those that Liz went over previously, such as jointly owned property, transfer on death or payable on death accounts, retirement accounts, life insurance, etc., they may decide that they do not want to go to the step of having a trust. The problem with some of those using that type of planning is that it doesn't account for unforeseen contingencies, such as incapacity, simultaneous death, if an account or other property is owned by a couple and they happen to die at the same time, they may not have a document that states where their asset is supposed to go. If you don't update your beneficiary designations to include secondary beneficiaries, then the asset may become payable to the estate. So there can be some problems with just doing it that way. Sometimes if you have all adult beneficiaries who you desire to receive assets outright at the time of your death, a will may be appropriate. This would allow assets to simply pass to them right away when you pass away with no oversight of a trust. Certain circumstances, individuals may want court oversight or probate. If family members do not get along or conflict is anticipated, they may decide that it is most appropriate to have a neutral third party involved to make sure that conflict does not get out of hand and their wishes are carried out. And in that case, they may decide that a will is the most appropriate means of planning.
And I would just add here, there are some attorneys who immediately go right to always recommending revocable trusts. I think this next slide does a good summary, and for us as a firm, it really does depend on your situation. And for younger couples who and younger families, you know, a will can really be just fine, kind of as a starter document to at the very least make sure you have a guardian appointed for your minor children, and you appoint an executor, you know, to handle your estate. So it really does depend on the situation, but this chart gives a good summary of the various advantages, and certainly doing nothing, or worse yet, you know, doing it yourself, which you know, can almost be worse consequences. Is you're not going to get any of the advantages. So you know, having a will, you're going to be covered on the very basic level. And again, for folks who have limited assets that wouldn't otherwise require probate, that can often you know, be a sufficient solution. And then the revocable trust for clients who have more assets accumulated, especially in their taxable investment accounts, not just in the retirement plans or life insurance. And they may own like a vacation home in another state, another real estate or business interests. When their asset situation, you know, gets more complicated as we, you know, just continue and accumulate wealth, then a revocable trust is probably going to be the better way to go. But again, depends on your individual situation. I'm going to talk a bit more now about just the general advantages of trust planning, and that's regardless of whether you use a will or a revocable trust. But so when I say trust planning, I'm talking about the advantages of leaving assets in trust for beneficiaries versus just outright. And this slide just goes over several advantages, and over the last really 10 years, since most states have enacted the Uniform Trust Code, of which Virginia enacted in 2000, I believe. So it's been over 10 years. Trusts have gotten to be a lot more flexible, and we can build a lot more flexibility into the trust and gain various advantages that you would otherwise lose just by leaving the inheritance to the beneficiary outright. So the first bullet here discusses when you leave assets in trust for your child, it prevents potential diversion of those assets to unintended beneficiaries. Like if the child were to get married and then go through a divorce, you know, if you were to leave assets to their inheritance to them outright, then those assets could potentially be commingled and be converted into marital property and then be subject to equitable distribution upon divorce. Also, if the child were to predecease his spouse, and then if that spouse were to remarry, and there's children, you know, grandchildren in this case, then potentially if the surviving spouse doesn't have the right estate planning in place, if something were to happen to them, your child's inheritance could end up going to their child's new spouses and perhaps their children. So particularly when grandchildren come along is when we find that, you know, for a lot of clients, this is important to them. They want to make sure that, yeah, I want to, of course, provide, you know, for my child, but I want to make sure that if something happens to them, that my legacy that I'm leaving is going to stay within, you know, my intended beneficiaries and ultimately go to the grandchildren. One of the other benefits of leaving the assets in trust for the beneficiary versus outright is you do gain additional asset protection. So if the beneficiary is sued or does go through a divorce, gets a judgment against them, if they get their inheritance outright, and if they buy a car or a house, that's titled in their sole name, then, and they get a judgment against them, that judgment creditor can file a lien against the property to satisfy the judgment. The assets that instead, if you were to leave them in a trust for the beneficiary, and you include the appropriate spend-thrift provisions, which we include in all our trust documents, it says basically, the assets in the trust cannot be made available to the beneficiary's creditors. So that said, you get that additional protection, but we build in a lot of flexibility in terms of the management of the trust. The beneficiary can serve as their own trustee, and under Virginia law, as long as their ability to make distributions to themselves is limited to the ascertainable standard of health, education, support, and maintenance, then the trust assets are not available to the beneficiary's creditors, even though the beneficiary is serving as trustee and essentially has a liberal access and control over the trust assets. And as Liz mentioned, for beneficiaries with special needs and of course minor children, leaving the assets in trust can provide that additional oversight that is needed, which I think, Liz, you're going to speak a bit more about special needs trust later when we talk about the different types of trusts. And then lastly, there is, it's not as important for a lot of clients with the increased federal estate tax exemption, but for clients of higher net worth, by leaving the beneficiary's inheritance in trust instead of outright, you can do some estate and generation skipping transfer tax planning to essentially, allow the assets and the beneficiary to have access to those assets for their lifetime, but you avoid the assets being included in the beneficiary's estate and potentially subject to estate or generation skipping transfer tax. And so there's those tax benefits as well to leaving assets in trust. So now I think we're going to move on and just talk briefly about different types of irrevocable trusts. So we talked about revocable trusts, which really don't have any tax advantages because, again, the grantor retains the ability to revoke and amend. They're usually the trustee and the beneficiary, and you don't get any asset protection with revocable trust. But irrevocable trusts are where, in comparison, the grantor does not have the power to revoke or amend the trust, and typically the grantor, the person who's creating the trust, can't serve as trustee or beneficiary. And so this enables the trust assets to be excluded from the grantor's taxable estate and not subject to estate tax. And it also allows the assets in the irrevocable trust to be protected from the grantor's creditors. And down there and on the list of different types of irrevocable trust, we do have listed self-settled asset protection trust, which is a special trust that Virginia law and a lot of other states allow a grantor to set up where they can be a discretionary beneficiary, and they can't serve as their own trustee. The assets in the trust would be protected from their creditors. And we do look at setting up those types of trusts, sometimes for physicians and other clients who have concerns about being sued. So because the trust is irrevocable, and because of the special provisions that are provided for under Virginia law, those assets are protected and are generally protected from the grantor's creditors. And so an irrevocable trust can be created either during your lifetime as a standalone type trust, or it can just be created under your will or revocable trust document go into effect at your death. So one note we wanted to mention here is, and again, we're not doing this as often for clients and, because of the increased federal estate tax exemption, which when I started my career was $600,000, which is what you could either give away during your lifetime or pass at your death and not have to pay any federal estate tax. And if your assets exceeded that, the estate tax rate for federal started at 50, going up to 55%, and then there was a separate Virginia state estate tax, which has since been repealed. But now the federal estate tax exemption, it was $5 million, and they doubled it with the 2017 Tax Act to $10 million, and it's increased every year for inflation. So this year it's $11.58 million is the amount of assets you can either gift away during your lifetime or pass at your death and not have to worry about federal estate tax. And in Virginia, we no longer have any state estate tax, although other states still do, like Maryland and DC. So for our clients who do have at the higher levels of net worth, like 10 million and above, and I'll mention, or I forgot to mention, that the 10 million exemption that was increased with the 2017 Tax Act is due to revert and sunset back to 5 million in 2026. And there's been a lot of talk that may happen sooner with if there is a change in control of Congress or the administration, and particularly with all of the building the debt and the expenses that we're incurring with the current economy, that perhaps that exemption could be reduced back sooner. And so with our clients who have higher levels of net worth, like 10 million and above, we're encouraging them, before this increased estate tax exemption disappears, which we know is going to disappear in 2026, but it could disappear sooner. Let's look at making some lifetime gifts. And certainly you could just make those gifts outright to your children, but you could also make the gift to a trust, an irrevocable trust, so that the assets are excluded from your taxable estate. And particularly with assets that are likely to appreciate, we've got, the stock market is depressed now. And so with assets that are likely to appreciate in the future, by, making that gift to an irrevocable trust, that future appreciation will also be excluded from the grantor's taxable estate and not subject to estate tax. So we're talking with clients that who do have that level of net worth, that it really is the perfect time to take advantage of the increased exemption and the depressed asset values and consider making some significant lifetime gifts to an irrevocable trust. And one of the trusts we have listed here on the list of types of irrevocable trusts is spousal lifetime access trust, which we also refer to as SLAT. And that's one way, and what a lot of our clients who are looking at making gifts, it allows you to make a gift to an irrevocable trust and get all those benefits, like I mentioned, of removing the value of the asset from your estate. But your spouse can still be a beneficiary, so you're not completely giving up your access to those assets. So SLATs are very popular today, along with dynasty trusts that you could design to continue in perpetuity for your children and future generations, and never, and avoid any future estate tax in any of the beneficiaries' estates. I know, and then Liz, we also have listed on here special needs trust and Medicaid asset protection trust, which is one of your specialties. So I'm just going to give you, turn over to you as to what comments you'd like to make on those types of trusts.
Thank you. So we already spoke about a special needs trust being a trust set up for an individual with special needs. And that's designed to be a slush fund, in effect, so that individual can maintain their eligibility to much needed means-based public benefits and have this money managed effectively by somebody else and available to pay for those things that public benefits don't pay for. One of the rules that Social Security and Medicaid have for these types of trusts is that it must be irrevocable when it's time to use it, and that it can only be used for the beneficiary's benefit. There are two types of special needs trusts. There are first party or payback, or sometimes we call them D4A or over 93 trusts. And that's if I put my money into a trust and I want to qualify for public benefits. And so that's the first party special needs trust. Two rules that are in particular for those types of special needs trusts. One, it has to be done before you turn 65. And two, at my death, if it were me, any money left in the trust first goes to reimburse Medicaid to the extent Medicaid paid. So if that special needs person never needs to go on to Medicaid, then that money doesn't go back to Medicaid. It's just if Medicaid has paid, they get reimbursed. And then the other type is a third party special needs trust, which is usually somebody else putting money into a trust for the special needs person. So mom and dad put the money in a special needs trust for their special needs child, and that allows them to keep that person qualified for public benefits. The other type of trust on there, the Medicaid Asset Protection Trust, are trusts that Virginia and I utilize to help protect assets in your estate and allow you to qualify for Medicaid. Right now, there's a 5-year look back period in which Medicaid can look to see if you did that, if you put assets in a trust or gave them away. So it has to be planned for ahead of time. And you must have a plan in place for what happens if you can't last those 5 years before you need nursing care. We get clients in all the time that first think that their revocable trust is sufficient to protect their assets for Medicaid. And that's not true, that's a myth. And then the second thing is they call me up and they say they want a Medicaid Asset Protection Trust right away to save my assets from Medicaid. And that's not always the way it works. And I will tell you that Virginia and I don't do a lot of these trusts because if it's your money and you're putting it into a Medicaid Asset Protection Trust, you lose control. And why would you want to do that? So some attorneys draft these as income only to get by that, assuming that the nursing home costs will be higher than the income generated from this trust. But it's really important that you work with a good elder law attorney to get a proper plan. I have an example of a woman who called me, and she was in her 70s. She went to a seminar on these Medicaid Asset Protection Trusts and met with the attorney. Her only major asset was her IRA. She had a $900,000 in her IRA. And the elder law attorney wanted her to cash it all in and put it into an irrevocable Medicaid Asset Protection Trust. But she was in her 70s in very, very good health. She had all her faculties. And I thought, well, why do you want to give up control? And she said, I don't want to give up control. There's your answer. So they're not for everybody, and it's a good idea to meet with an elder law attorney. So maybe in the future, which brings us to when do you need to update your estate plan? And Virginia is going to talk to us about that.
Right. So we get asked frequently, when should you update your estate plan? And a good rule of thumb is anytime you have a major life event or change in your life, it's a good time to sit down and look at your documents. So marriage, divorce, birth of a child or grandchild, when a spouse or other beneficiary passes away, when your children reach age 18 and are no longer minors, if you move to another state, or if there's a significant change with regard to your financial situation. We have on here winning the lottery, and I hope we're also lucky to have that problem. Whenever there's a major change in the tax law, it's a good time to review your estate plan. So Melinda referred to the change in the taxes that happened in 2017. That was something that was in the news that a lot of people knew about, but they may not have been aware of the change with regard to the estate tax ceiling. In general, we recommend that at least once every 5 years, you review your documents with your attorney to make sure they reflect your current wishes and that they comply with the law as it stands then. And for some of these situations, it's a really good idea to talk to your estate planning attorney before the situation happens. So for example, with regard to marriage, if you have accumulated assets, if that is a later in life marriage or a second marriage, you should talk to your estate planning attorney before you get married to talk about whether a prenuptial agreement is a good idea. Or before you get divorced, if you already have estate planning documents, it's a good idea to review those with your attorney before you go through the divorce to determine whether that will affect your divorce situation.
Yeah, Virginia, if I can make a couple comments back to the changes in the estate tax law. We're seeing a lot of clients, you know, they may have a will or revocable trust in place, but it was done maybe 10, 20 years ago when like I said, when the federal estate tax exemption was much lower. And one of the primary updates that we do for those married clients is the traditional estate tax planning that we used to do when the exemption was much lower. We would provide for at the first spouse's death whatever assets that were in the deceased spouse's name, a revocable trust that up to their remaining estate tax exemption would go into a family trust for the benefit of the surviving spouse and the children. And the benefit of that planning was the family trust was designed so that it was not includable in the surviving spouse's estate. And that was beneficial when the exemption was like $600,000, but not really needed now that the exemption is so much higher. And we also have the ability to the portability election, which we didn't have prior to the 2012 Tax Act, where you can now make an election to just transfer the deceased spouse's unused estate tax exemption to the surviving spouse. So going through the complexity of creating automatically creating this family trust at the first spouse's death is often not necessary for a lot of clients, and it can actually be disadvantageous from an income tax perspective, because due to the fact that the assets in the family trust are not includable in the surviving spouse's estate, and that was the whole purpose of why we did that sort of planning, you don't get any step up in the cost basis for income tax purposes at the surviving spouse's death if those assets would have been includable in the surviving spouse's estate and not in the family trust. So for various reasons, that's one of the primary updates that we do for a lot of clients. And just one more comment, I'm updating a client's document now she's going through a divorce, and her current husband, who she's not speaking to, and they have 2 children, is co-trustee of her revocable trust, and there was no provision. We include typically a termination of marriage, or even if you're separated, you know, our trust documents say, you know, my spouse no longer has any role in serving as a fiduciary under my documents, and they're not a beneficiary to the extent that Virginia law allows me to disinherit them. But she didn't have that type of provision in her document, so we did an amendment to remove him as co-trustee of her trust, which she was very happy to do. So Liz, did you have any other comments on?
Yeah, we had a guardianship case that involved one of those old AB family trusts, but the gentleman was too incapacitated to update it. I think it was from like 1996 or 1997. It was really old. And the spouse had never done any of the financial stuff. And all of a sudden her husband's got really bad Alzheimer's, and we had to do a guardianship because she could not claim his required minimum distributions because her power of attorney was so old, it didn't have anything in there allowing her to take those. And we also needed the court authority to change his trust because once he became incapacitated, his trust became irrevocable. So we got the court's authority to fix that because I figured she was just too unsophisticated to be able to handle doing 2 tax returns when her husband died, one for that special trust that was in his documents to preserve his estate exemption, and then her own individual tax return. So it was another reason they should have kept up to date with their documents.
Yeah, so your documents are not set in stone, and it's always good, as Virginia said, to revisit them at least every 5 years and just see what, what's changed in your current situation. We're going to go over this slide, the last couple slides briefly, because we do want to allow some time for questions. But when we work with clients, we do take a holistic, comprehensive approach, and we also prefer to collaborate and work with the client's advisors. We always, get a better result for the client. So we don't just draft their documents and send them on their way. We look at other planning considerations like we have listed here. We definitely want to make sure we review all the beneficiary designations and look at how the assets are titled. We encourage clients to consolidate. We often see, particularly with the do-it-yourself investors, have 5 or 6 different investment accounts at Fidelity, Vanguard, and other places, and it's kind of their hobby, doing the investments, and either the spouse then has no clue what to do if they pass away, or the children don't even know what accounts even exist. So consolidating accounts makes it much easier for your family members who you've named as your executor or successor trustee to be able to step in and really make sure everything is properly managed and handled in accordance with your wishes. Digital assets are also, we always want to make sure that folks, at the very least, keep a list of all of your online accounts, because a lot of us don't get account statements in the mail anymore, and so keeping at the very least a list of all your online accounts with your usernames and passwords, which of course are becoming more and more difficult for us to keep track of. So there's other services like LastPass, and even like Norton has a password storage tool, even Google Chrome, which is how I keep track of my passwords these days. So, and not only the passwords to your online accounts, but the password to your computer, the password to your phone that we're all stuck to. So I did write an article recently on this, and it's posted to my LinkedIn page. I will have it posted to our website as well, that goes over these, which is really becoming more and more important because we're doing everything electronically. So, and then we also look at insurance. considerations like long-term care planning, long-term care insurance, and then we work with the financial advisor to make sure that the insurance is in place. I'm looking at life insurance also, especially for business owners, and also asset protection planning, and asking, do you have umbrella liability insurance? It's a very inexpensive thing to add to your current homeowners an auto insurance policy, and it ensures that if somebody sues you and your policy limits are exceeded, this umbrella liability insurance kicks in to protect them. Again, your assets, a judgment lien from being filed against your house and that sort of thing. And then we also look at, doing some of the more advanced planning, like I talked about with gifting, whether that be annual exclusion gifts, which the IRS allows you to give every year. It's now $15,000 per donee per year that you can just give away and not have to file any gift tax return. And again, for folks at higher levels of net worth, that's the easiest way to start, make sure you can transfer wealth to your beneficiaries now and reduce the size of your taxable estate. We also, talk about, charitable objectives and charitable planning, and, mainly just all of, taking that comprehensive approach and working, we feel with a team of advisors really will provide so much, not only peace of mind, but save a lot of time and money for you and your family. So we try to cover all those planning considerations as well. Liz, I think you're going to cover this next slide.
Yeah, and I'm going to go pretty quickly so we'll have time for questions. The first thing, if you're going to work with an attorney, is to organize your financial information prior to the meeting, or have your financial planner give you some sort of worksheet that goes over your estate. The second thing is ask questions. How much of the attorney's practice is focused on estate planning? How much is focused on estate administration? I can tell you that Virginia, Melinda, and I have all been greatly enhanced in our abilities to draft robust and comprehensive estate plans because we do the administration piece. It's really different when you're on the other end and you're seeing how the reality plays out in this trust document. And so, oh, that's why I want that paragraph in there. So that really helps. Their billing structure, how do they bill? Hourly, flat fee, what's included in the flat fee? After your estate plan is complete, to review and update your asset titling and beneficiary designations. Does the attorney do that? Do they call you if something changes in the laws? Do you call them if something changes in your life to avoid crisis planning? That's a really great idea because unfortunately, Virginia and I do a lot of crisis planning, which are the guardianships and conservatorships. The other thing is that, do you want your family members to be part of the planning process? We have a family meeting with your adult children so that we can all sit around the table and go over your estate plan so that they see what it is that you want and what you want to do. So do you discuss this with your family and consider including them in the estate planning process? If you want to schedule a meeting with any one of us, send an email to trustestate@mccannlaw.com and we can set up a meeting. And finally, this chart really summarizes what we've talked about today in all of these key areas of having a well-designed, comprehensive estate plan.
Great. Thank you. So I think we're ready now to take questions. Okay. So one of our questions is, who do you recommend as your voice in your advance medical directive? And we talked about that a little, but as we said, one of the most important things is someone that you trust, someone who can be a good advocate for you, who won't be easily intimidated, Doctors and hospitals can have a way of seeming to speak with a voice of authority, and sometimes that can be overwhelming for family members, especially if they feel like they don't understand the medical or scientific terms that are being used. So Liz talked a little about sometimes using the option of if there's no friend or family member who can fulfill that role, consider having a professional in that role, someone who's practiced in dealing with those types of people and can really speak up and not be afraid to advocate for you. And then once you've selected that person, make sure that you have conversations with them and let them know what you want, what your wishes are. Okay. So our next question is quite detailed. I think this question may be better answered in a private meeting. Liz and Melinda, can you see it? It's regarding.
I have been reading through it, and I can take it since it pertains to, I guess, a bank perhaps being difficult in allowing someone who was appointed, a child who was appointed as the person's agent under their financial power of attorney, to be able to access the account.
It looks like this is after the principal died.
Yeah, and you know, if that's the case, you know, as you mentioned, Liz, you know, the power of attorney, the financial power of attorney, terminates at death, and so the agent, the child, I guess in this case, who was appointed as under the financial power of attorney, you know, would no longer be able to have access to that account. And so the second part of the question is, can said bank demand that the child under the financial power of attorney, I'm assuming, qualify as executor before gaining access? And yes, I mean, that essentially, like I said, the account is frozen, you know, if assuming the bank, you know, is aware of the person's death, then yeah, the account is frozen at that point, and if it's not titled in the name of a revocable trust, if it's just titled in the customer's individual name and there's no payable on death designation, then you're going to have to resort to seeking to be appointed as executor if there is a will, or if there is not a will, seeking to be appointed as administrator.
One thing that I wanted to add is if the aggregate value of those assets that are not owned jointly or have a designated beneficiary, so like the bank accounts, if the aggregate value of all of those is less than $50,000, there is the Small Estate Act in Virginia, and that can help you without having to do a qualification, a probate with qualification.
I'll just add a final comment. You know, we hear this often, and you know, in terms of, well, the bank told me I can't do this, and the bank said no to that. You know, when someone passes away, or if you're serving as agent under financial power of attorney, and every bank is different, and it can be frustrating. But you know, because of the increased elder fraud and fraud in general, that is kind of why, you know, there's all these kind of hoops that you have to jump through, unfortunately, and that's why it's really it's important, you know, people try to handle an estate themselves, and then they start encountering these sorts of roadblocks because it's not something that they, you know, do for a living, and so oftentimes that's, you know, we encourage folks, you know, come to us sooner rather than later so that we can help guide you through what can be a very frustrating and time-consuming process.
Yeah, the bank could be wrong.
Right. So Melinda, someone has a question. Is the $15,000 annual gifting exclusion for each individual, not a household? So could a husband, wife gift $30,000 together as their annual gift? Do you want to answer?
Yes, absolutely. So it is each, per individual, per spouse, you can give $15,000 per donee per year to anyone. They don't have to be related to you, anybody. And that's indexed periodically for inflation. A lot of people might recall it used to be 10,000, and it's been increasing. They increase it in $1,000 increments, so it doesn't increase every year. So it's been at 15,000 for the last couple of years.
And we have a question about pros and cons of naming multiple children as successor co-trustees. We talked about that a little bit in terms of selecting fiduciaries, but this can be problematic in the circumstance, either when the parents are alive or after they've died. If the children don't agree and don't have a common viewpoint, it can lead to conflict, no clear answer. So we do encourage our clients to strongly consider selecting either one adult child to serve as the primary and maybe additional children as the secondary successor trustee rather than as co-trustees. Or if it's a high conflict situation, again, that may be a situation where a professional trustee is appropriate, so that conflict doesn't end up becoming a problem. But that's definitely a good question. One other question for you, Melinda. What are you advising client on current gifting estate planning techniques given the sunset in 2026?
Yeah, like I said, with the exemption being at 10 million now and indexed for inflation, but it sunset in 2026 back to 5 million or even sooner. So that's an extra 5 million that for the folks who can afford, first of all, to to not depend on those funds for their own resources and support, consider making a significant gift of those funds to, like I said, an irrevocable trust. And if they're married, the most common gifting that we're seeing is designing it as a SLAT, spousal lifetime access trust. So like I said, the grantor can't be a beneficiary and they can't be a trustee because we want it to be the trust assets to be excluded from their taxable estate, but their spouse can be beneficiary. Or if they're not married, maybe they name their sibling as beneficiary, just so that you have some kind of backdoor indirect access to those trust funds if you need them. And there's other more advanced planning like GRATs and shared remainder trusts, and that are really more intended to freeze the value of your taxable estate rather than reducing it just by shifting future appreciation to the beneficiaries of the trust. But that involves some additional complexity, and for a lot of clients who just want to make a significant lump sum lifetime gift now to take advantage of the increased exemption, we don't really have to go to those more complicated lengths in gifting. We can just make a direct gift to an irrevocable trust and take advantage of the increased exemption before it disappears, and get those assets and future appreciation out of their taxable estate.
Great. So I think we've answered all the questions. So if there are no others, we can wrap up our webinar. We want to thank everyone for coming. We hope this has been informative and helpful. Again, if you'd like to get a copy of the slides or if you have any other questions, please feel free to email us at trustestate@mccannlaw.com, and we look forward to hearing from all of you. Thanks.
Thank you.
Thanks, everybody.